Hello and welcome. My name is Darren Murdoch. I am a solicitor and notary public with Waddell and Mackintosh Solicitors in Troon. The presentation which I'm about to deliver was originally delivered to those trainees in attendance at our Royal Faculty of Procurators in Glasgow and Scottish Lloyd's Society Tcpd programme, and this occurred on the 22nd of January of 2021. A number of my peers on the Slas Council have viewed this particular presentation and thought it would be worthwhile entering the presentation in terms of delivering CPD to the profession in accordance with the new Slas offering. As regards those that were in attendance at the meeting on the 22nd of January, I thought it only appropriate to give them a very warm welcome to the profession and to commence the presentation on some career-saving guidance, and hopefully you will glean some useful points in relation to the presentation yourself. This is a quote taken from the late Professor Meston's seminal text on Succession Scotland Act 1964. This quote featured in both the 4th and 5th edition and may well have featured in later editions. In terms of the quote, I could not agree more with the late Professor Meston. As an experienced executory practitioner, I find that no 2 days are the same in practice, and every executory brings with it its own challenges. For the benefit of those in attendance at the meeting on the 22nd of January, I pointed out that this is what they've been working towards. This is what they've been seeking to achieve, and I'm conscious that we should hold dear that which we have achieved ourselves. And during the course of the presentation, I'll come on to discuss a case whereby the practicing certificate was at risk. In simple terms, it is the duty of an executor to implement the testator's wishes in accordance with the will, and in the event there is no will, then in accordance with the Succession Scotland Act 1964 as amended, as regards an intestate estate. Now, an executor should account to the residuary beneficiaries for their intromissions at the end of the executory period. I appreciate that not all estates shall require confirmation. However, if an executor proceeds to administer an estate without confirmation, this is known as a vitreous intromission of the estate, which can give rise to personal liability of the executor to creditors up to the value of the deceased estate. Now, a useful piece of legislation in terms of managing client expectations is the Act of Settlement of 1662. This particular act states that an executor is personally liable to creditors if the executor should distribute the estate within 6 months of the date of death. That is not the date of confirmation, it is the date of death of the deceased. After 6 months have passed, it is the beneficiaries that the creditors can go after. Almost goes without saying that an executor should not act in their own interests. If they do so, then they can be removed from office if they breach the principle of auctor in rem. Now, as regards an executor that transgresses from their authority within the testamentary deed, the executor can make an application to be excused for their actions to the Sheriff Court in accordance with Section 32 of the Trustees Scotland Act 1921. And if the court finds that the executor has acted honestly and reasonably, then the court may excuse the executor from their transgressions. Moving on to the important subject of legal rights, I would remind you that legal rights cannot be defeated by a testamentary deed. This, of course, brings into question the extent as to the testamentary freedom that is afforded to your clients. Also, by way of a reminder, legal rights amount to a third share of the net movable estate if there is a surviving spouse, or a half share of the net movable estate where there is no surviving spouse. Now, legal rights carry a long period of 20 years prescription. I will come on to a case which I dealt with in practice that this period of prescription applied to, and the executor was brought to task in relation to the legal rights issue in that particular case. Be mindful of accepting a legal rights discharge in relation to the age of legal capacity. Scotland Act 1991. We'll come on to discuss this further later in the presentation. Now, a right of succession or a debt of the estate, I would argue it is merely an academic debate. Let the legal theorist argue the point. I would simply urge you to deal with legal rights in practice. This brings us on to the very important case of the Law Society of Scotland versus David Harrow Campbell. Parties to the case were A, the deceased. Now, he was survived by his spouse of the second marriage and the son of the first marriage and the daughter-in-law. Party B was the solicitor that was originally appointed as executor nominate in terms of the will of A. Party D, the surviving spouse, was advised by B of the legal rights claim in respect of the surviving son. To say that D hit the roof would be somewhat of an understatement. She threatened all merry hell, and she stated that she would destroy B if he proceeded to advise the surviving son of the legal rights. Now, David Harrow Campbell stepped in. He offered to be assumed as executor and for B to decline office. This is what happened. David Harrow Campbell had agreed that he would obtain confirmation and then step down as executor of the will. Now, the surviving daughter-in-law got wind of the death of A, and she pushed the surviving son to claim the legal rights, and a report was made to the Law Society of Scotland. An investigation occurred. Now, David Harrow Campbell did not go blindly into this particular minefield. He searched the journal for advice, he looked at Curry and confirmation, and he had the issue that no advice, rules, guidance was readily available. So he's somewhat entering into the dark on this particular one. Now, in terms of the expert witnesses to the tribunal case, it was John Kerrigan, the late Professor Meston, William Grant and Mrs Rennie. Now, the charge which was levied against David Harrow Campbell was one of professional misconduct. Now, the charge that was levied against David Harrow Campbell was one of professional misconduct, so his practicing certificate was on the line here. Okay, the result of the tribunal hearing was that David Harrow Campbell was exonerated. And moreover, in terms of the last sentence of this quote, it is quite significant that the tribunal found it somewhat unfortunate that such serious charges should be framed in such generalised terms when the allegations are so serious. Now, as stated earlier, at the time of David Harrow Campbell acting, no guidance was available, there were no rules in place. This is not the case. Following the tribunal hearing, guidance was published on the Law Society of Scotland website. I would encourage you to familiarise yourself with the guidance and ensure that you understand the guidance. Returning to the expert witnesses, William Grant has stated, "But for the grace of God, there go I." The late Professor Meston had stated that he had fudged the issue in terms of his seminal text, which we mentioned at the start of the presentation. Mrs Rennie had stated that she commonly gave funds to parents of children in order to meet their welfare needs. She would be appalled if she was to face a similar charge given those circumstances. Now, John Kerrigan stated that he would not only have resigned as executor, he would also have resigned as law agent. He would have put a covering note into the file, and if the file was mandated out to another firm, he would give a warning that there was a legal rights issue. Now, please be mindful of the fact that David Handel Campbell was then, this is now. If I may borrow a final quote from the late Professor Meston, and that is to say that if a child's right to legitimum may be defeated, this leaves an interesting jurisprudential question of whether the child can be said to have a right at all if there is no estate on which the right can operate. If I may also throw in a quote from Dylan, and that is to say, the answer, my friend, is blowing in the wind. Let it blow, let it be a question for the jurisprudential theorists amongst us. Simply deal with legal rights. Now, turning to a case which I dealt with in practice, I took instruction from Mrs. McGlumford concerning her will. I breached the subject of the surviving children. She intimated that she had 2 estranged children, and to quote her, why was I asking? I advised her of the issue of legal rights. To say that she was somewhat angered would be an understatement, for she intimated that her mother had passed away some 17 years previous. She had not received a penny from her mother's estate. I inquired as to the executor and the firm of solicitors that dealt with her mother's estate. I wrote to that particular firm. They provided me with a copy of confirmation and a legal rights claim calculated at circa £13,000. I wrote back adding a further claim for 17 years worth of interest. The settled claim was in excess of £20,000. You do not wish to be the solicitor that has to approach your client some 5, 10, 15 years following the passing of their spouse and ask for a sizable sum in settlement of legal rights. Returning to Mrs. McGlumford, I ensured that I wrote in terms of a note within her will packet that there were legal rights issues, and I tried to obtain as much information in terms of the estranged children. Now, I have discussed legal rights with various members of the profession, and occasionally I come across individual solicitors that are of the mindset that they will deal with legal rights on the second death when there is estranged children. I would caution against this particular path, and I would remind you of the discussion which we've already held as regards David Handel Campbell. Having examined some of the problems which can arise from dealing with legal rights, it's perhaps appropriate to look at how legal rights can be legitimately defeated. I have many a client who have held discussion with, and they've given me good reason why they do not wish their estranged children to inherit from their estate. First case I'd like to turn to is that of Care Petitioners 1968, and this particular case is important because it arose some 4 years after the Succession Scotland Act 1964, and this particular case brought to light the potential solution of an artificial intestacy. Now, the background to the case is such that the deceased was survived by his spouse, Mrs. Kerr, and the 2 children. The 2 children were intent upon claiming their legal rights. Mrs. Kerr was advised to renounce her entitlement under the will, claim her prior rights, and thus extinguishing the whole of the estate. In terms of her prior rights, the children got nothing. Now, Care Petitioners will not always be a solution. It very much depends on the value of the estate and the prior rights threshold at the time of death. Also, be careful in terms of if you're going down the road of Care Petitioners to ensure that there's no destination over in relation to the will. Another means is transferring funds out into a trust. Now, if you're taking this particular path, you must ensure that there is a letter of wishes signed in terms of who is to benefit from the trust, and it is lodged with the trustees, and it is good practice to keep a copy of the letter of wishes with the client's will. I appreciate legal rights are deductible from the movable estate presently, and I appreciate it is not a perfect solution, but if your clients are able to invest the majority of their wealth in heritable property and have a fund to carry them through in terms of movable assets, this is one way in which they can defeat legal rights. Now, turning to discharges of legal rights, be mindful in terms of Age of Legal Capacity Scotland Act 1991, in particular section 3 thereof. Now, a 16-year-old does have capacity, however, any contract signed between the ages of 16 and 18 may be reduced upon an application to court in terms of section 3 of the Age of Legal Capacity Scotland Act 1991, and in terms of accepting discharges from your clients, you should ensure that they have been advised to take independent legal advice, advised of the fact there are legal consequences to signing the discharge, and ensure that they are given an accurate statement of their legal rights entitlement before any discharge is received and accepted. Turning to some key advice which you can provide to your clients, which can help prevent problems arising further down the line, I always advise my clients to tell them nearest and dearest where their principal will is located. Now, you'll see every month, more often than not, there's an advert in the back of the journal. Does anyone hold a will for the ubiquitous Mr. and Mrs. McGlumford? And I regularly receive emails from the local faculty asking if anyone holds a will for the late Mr. and Mrs. McGlumford. I also advise my clients to lodge an appropriate inventory with their will and to keep the inventory updated. I say appropriate, for I once opened a will packet only to find an inventory detailing a whisky collection. Now, as regards safe storage of the will, I am in the habit of scanning a copy of the will to our database. I'm in the habit of providing the client with a copy will, and I'm in the habit of putting a copy of the will in the paper file. I advise my client of the necessity of securing their principal will, and as regards thereof, in the event the client mandates the will out of the firm to hold on their own records, I advise them of the principle of animus revocandi, that is to say that if the will goes missing in the hands of the testator, it is considered destroyed by the testator. Touching once again on legal rights, if it arises during the course of the discussion with the client that there are estranged children, I try tactfully to get as much information as I can in relation to the children. I advise the client in terms of legal rights and the potential solutions in terms of avoiding the payment of legal rights, and I scroll over the file that there are estranged children. I put an entry in the database, and I also put a note within the will packet that there are estranged children. Turning to recent changes to executive practice in relation to the Succession Scotland Act of 2016, those of us that were hoping for a revolution would have felt somewhat let down by the 2016 Act. It really simply tinkered round the edges. As regards legal rights, well, there was nothing really in the 2016 Act that materially affected legal rights. I appreciate that the assimilation of heritable and movable estates concerning legal rights has been a discussion that has been ongoing for decades. Now, perhaps the most important provisions within the 2016 Act were the effect of divorce upon executory estates. That is to say that any will containing a legacy to a former spouse will no longer be valid, and the appointment of an executor or trustee for that matter in terms of a former spouse will also fall, and survivorship destinations will be treated as though there is no special destination. The property will simply be held jointly. I give the caveat that if there is an express provision within the will stating that despite divorce from X, they still wish to appoint X as their executor or leave a legacy to their former spouse, then this will still be valid in relation to a divorce from a former spouse. Further changes brought in terms of the 2016 Act arose in terms of the potential for rectification of wills. This brought to light the English case of Marley v Rawlings, where the testators, a married couple, signed one another's wills. Perhaps a bad day in the office for that particular solicitor. This particular case went all the way through to the Supreme Court, and the insurers paid out in relation to the mistake that was made, and the court allowed for rectification of the wills. If you're going to seek an application for rectification of the will, you're going to have to rely upon good meeting file notes, affidavits, etc. And it is a case that the deceased must be domiciled in Scotland, and the will must not be prepared by the testator but upon their instructions. Perhaps the greatest change in recent decades concerning the rules in relation to inheritance tax followed the Conservative election manifesto pledge, whereby they promised to take the family home out of the IHT equation by increasing the threshold for married couples and for civil partners. Now, it is critically important that the applicable residence falls to direct delineal descendants, so you're looking at children, grandchildren, or even great-grandchildren. The qualifying residential interest must not be a buy-to-let property. Now, this particular additional allowance arose in incremental amounts from the 6th of April 2017, and the potential now is an additional 175,000 on top of the personal allowance of 325. So therefore, in terms of the second death, it is a matter that there is a potential IHT allowance of 1 million. It is transferable between spouses and is backdated indefinitely. There is also a downsizing allowance as long as the property was sold on or after the 8th of July 2015. Further comments I'd like to make in terms of inheritance tax additional nil rate band is in respect of taking your client's instructions concerning their will. Please avoid preparing wills whereby the heritable property falls to discretionary trustees. Be mindful of the fact it is only direct delineal descendants that can inherit the additional nil rate band. As regards IHT reclaim, presently we live in a crazy housing market, and the value stated in confirmation is often not the value which is achieved for the heritable property, and in the unusual event that you overpay tax on the heritable property and you're seeking to reclaim the tax from HMRC, do not expect to receive a cheque in the post for up to 2 years from HMRC when you're seeking to reclaim inheritance tax. I am of the opinion it is fundamentally important that executory practitioners are both diligent and inquisitive. I appreciate that there is a high likelihood that both experienced and inexperienced practitioners will make mistakes. I would add to this that we deal with large sums of money, and we owe it to our client to ensure that we administer the estate to the very best of our ability and that we learn from our mistakes. Now, as regards being diligent and inquisitive, I previously dealt with a late client's estate. The client was somewhat of a hoarder. He rented space at Kilmarnock Removals. Upon his death, the executor arrived at the office with sacks full of paperwork. I sifted through the paperwork and I soon realised that the present deceased had retained paperwork from his predeceased brother's estate. In searching through the paperwork, I found a post-it pad with a sort code and an account number on it. I thought that this was simply wound up in relation to the predeceased brother's estate. Nevertheless, I wrote to Aviva, I tracked the policy or the account down to Aviva. Aviva wrote back confirming there was some 57,000 in that account as regards the present deceased. Now, had I not been so inquisitive and diligent, then that particular sum of money would no doubt still be sitting with Aviva. It is unfortunate that the actions of an attorney operating under a power of attorney are often not discovered until the deceased passes away. At this particular point, the OPG has no powers of investigation. I had uncovered a potential fraud in relation to a POA in relation to an executory estate. I reported my findings to the executors, and they instructed me to inform the CID. Further investigations were undertaken, and it transpired that there was a potential fraud of 160,000 in relation to that particular account. On another estate, I wrote to HBOS and I quoted 3 account numbers which I was aware of. HBOS wrote back in relation to one account. There was no mention of the other 2 accounts. I visited my local branch of HBOS. They looked into the matter and they actually informed me of 2 further accounts, confirming the other 2 original accounts were closed. The 2 accounts which they informed me of were dormant, and there was some 50,000 in that particular account. So it is critically important that, as I say, executive practitioners are both diligent and inquisitive. We owe it to our clients. Continuing with the theme of ensuring great care and attention is taken when dealing with executory estates, I would like you to take a second to examine the slide in front of you, and I'll give you a moment to do so. Now, you will no doubt peruse the slide and think, well, hold on a minute, 9 tens are not 91. Of course, you're perfectly correct, and I give this particular example because this is perhaps what is in the mindset of your client. They will not remember or recognise the remaining additional excellent work which you have done. They will simply remember the mistakes which you make. Therefore, I would highlight the necessity of attention to detail when dealing with executory estates. You do not wish to look foolish in front of your client. Prior to moving on to the practical stuff of executory practice, I would draw your attention that occasionally our lives are made somewhat more difficult through no fault of our own, and in terms thereof, I would state that a number of my clients have previously asked me, is a solicitor the same as a lawyer? I simply refer the client to the Solicitors Scotland Act 1980 section 31 and confirm it is an offence to hold oneself out as a solicitor if not on the solicitor's roll, whereas it is not an offence to hold oneself out as a lawyer. This has led to some entities claiming to be Law Firm of the Year from that well-known award by the INTL magazine, which allows you to award yourself whichever award you may care for, as long as you pay the subscription fee of £5,000. This led me to write an article which was published on the Scottish Legal News and the Gazette of the Scots Law Agents Society, and that particular article will still be available. And I wasn't calling for the summary execution of solicitors or lawyers for that matter. That was a quote from Shakespeare, Dick the Butcher, and please feel free to have a read on Scottish Legal News if you so wish. The article will still be available there. I have previously came across a firm locally whereby they were holding themselves out as solicitors. I brought that to the attention of the Law Society. They removed all reference to them acting as solicitors, and there were 1 or 2 historic references that they haven't removed claiming to be lawyers. And they were stating in their advertising that if someone doesn't have a will, their estate will be divided according to legislation from 1927. So they're a few years behind the times there. I have also perused an attorney written by a so-called lawyer, whereby they authorised the attorney to transfer heritable property whether situated as opposed to wherever situated. Having touched upon bad practice, I would like to touch upon what I consider good practice in terms of the practical elements of dealing with an executory estate, and the next section of this presentation will cover the following slides. Starting with the initial client meeting, I am always in the habit of looking out the key deeds prior to the meeting. So in particular, I'm looking at who the executors are in relation to the will and any codicil relative thereto. I'm looking at funeral instructions, and I'm looking at how the estate is to be distributed. Turning to the title deeds, I'm particularly interested if there is a survivorship destination and any subsequent evacuation thereof. As regards survivorship destinations, I would like to state that I have previously attended a CPD event held by Lockton, and there have been previous claims brought against solicitors for incorporating and for not incorporating survivorship destinations. Damned if you do, damned if you don't. I would advise against incorporating survivorship destinations in terms of restriction of testamentary freedom, and as a matter of course I incorporate into my terms of engagement that unless specifically instructed to do so, we will not incorporate survivorship destinations within dispositions in favour of our clients. Okay, further steps that should be taken in advance of the initial client meeting is simply to peruse the titles, ensuring that there is an adequate description of the heritable property. I appreciate that the keeper is tasked with completing the land register by 2024. I simply don't think this is going to happen. Do not take the titles for granted. I previously dealt with an executory whereby there was keeper-induced registration, and the keeper married the deceased mother to her son and also introduced a survivorship destination which was not on the seizing deed. Now, I'm in the habit of printing off a copy of the wills for each of those in attendance, and I'm looking to check any changes to address details for beneficiaries and executors, and any predeceasing beneficiaries or executors. In the event that the estate contains heritable property, I advise the family obtaining 2 extract death certificates. In the event you inspect the title and you identify that there is a special destination, be mindful of the fact that a later testamentary deed does not in itself evacuate the special destination unless it conforms with the Section 30 provision of the 1964 Act. I've also touched upon and covered the provision in relation to divorce in terms of special destinations, and the general rule is that a later will does not evacuate a special destination, and the exception is when one party funds the whole purchase, and that is only in terms of their particular half share of the heritable. So we arrive at the initial client meeting. I am all too aware that we're dealing with a vulnerable individual more often than not, and that the client may well have 1001 questions, but the questions at the forefront of their mind is in respect of how long is it going to take, how much is it going to cost, and what's this thing called confirmation. Now, turning to the first of these questions, I remind the client of the 6-month rule in terms of the executors being personally liable for any debts of the estate, and I also advise the client that executors can make interim payments at their own risk. Now, it is perhaps useful to advise the client that both HMRC and DWP do not work in terms of the same turnaround times as most institutions. As regards the tricky question of how much is it going to cost, I advise the client that we charge in terms of a time and line basis in accordance with the terms of engagement letter, and I provide the client with 2 copies thereof, and I also inform the client that the file will be independently audited, and if pushed, all I can state to the client is that we don't know how much work is involved. All I can give is a simple rough estimate, and if so required to do so, I can certainly have an interim audit in relation to the file. Now, as regards why is confirmation required, well, if there's heritable property, I explain that the certificate of confirmation is a linking title. If there's no heritable property and the asset holders are requesting confirmation, I explain what confirmation is to the client and why it is so required. Continuing with the initial client meeting, now we owe a duty to our clients to advise them that in the event it is a small estate, that is to say it is below 36,000, that the sheriff clerk has a duty to assist if confirmation is required. Now, ideally, the family will provide you with a full inventory of the assets. However, if they don't, it is worthwhile getting copied bank statements, looking for dividend payments, looking for pensions, etc. Now, I advise the client in terms of prior rights if applicable, and let's remember the legal rights issues that were previously discussed, and also remember Kerr Petitioner's 1968 case. Now, at the end of the day, you're looking to receive a discharge from DWP, Recovery from Estates Department. I appreciate that the DWP have many tentacles, and it is this particular department you're looking to receive a discharge in relation to. Sticking with the initial client meeting, now in terms of an extract death certificate, it states at the bottom thereof it is a copyright offence to take a copy of an extract death certificate and pass it off as an original. It is not, however, an offence to copy the extract death certificate and confirm that it is a copy of an original, and by and large this is acceptable to all financial institutions. I'm advising the client in relation to the IHT provision, and if it is a second deceased, I'm looking to see if it is a simple case of an IHT 217 or a full IHT returned to HMRC. If there are matters to be dealt with concerning HMRC and their outstanding tax issues, make sure that you have the client sign a Form 64-8 and send the same to HMRC, otherwise you will get nowhere with HMRC if you are to phone them up. I'm also explaining to the client the duties of an executor, and that is to say that they should basically ensure that they adhere to the testator's wishes in accordance with the will and also in accordance with the law. I appreciate there's a lot going on prior to and at the initial client meeting. Arguably the most important point is identifying the client, and never forget this point. The surviving spouse may not be your client, it is the executor that is your client, and you take instruction from the executor. If it happens to be coincidentally the surviving spouse, that's all fine and well. If not, do not get confused as to who your client is, and I underline this particular point. Now, provide the client with terms of engagement letters and obtain 2 forms of ID in terms of Rule B4. You're asking the client, has the death been registered, and you're adding value to your client's service. Advise them of the 8-day grace period. Advise the family of the Tell Us One service and ensure you're advising it is a free service and the value of that particular service. Advise the client what it takes to register a death, and that being a note of the national insurance number, last occupation, where they resided, marital status, payments details, etc. In the event that there is no will, you're sending an email around the faculty. You may wish to choose to advertise in the Journal of the Law Society. You're also advising the client if it is a matter of intestate succession in terms of the petition to court and the necessity of a bond of cation if it is not the surviving spouse that is the executor. Upon conclusion of the client meeting, I'm seeking to send the will by special sign for delivery to Registers of Scotland, That way it's ensured I'm not sending it by DX. Prior to the will leaving the office, I'm ensuring that there is a copy scanned to the database and that there's a paper copy in the file. I'm writing to the Office of Public Guardian, giving notification of the death. The authority of an attorney ceases upon the testator's death. As regards writing to financial institutions, if you are somewhat in a search in the dark, then you're seeking banking statements going back 6 months. If there's dividends in relation to the estate, then you're seeking banking statements going back 12 months. Now, you're ensuring that you request closing statements from the bank. If you don't ask for closing statements, they will not deliver them. And you're looking to refer to these closing statements at the end of the day in your account of charge and discharge. Tackling the question in relation to confirmation and as to whether or not it's required, I simply remind the client as to the personal liability of the executor in the event that they elect to proceed without confirmation. I would also state that confirmation makes a will provative but says nothing as to the validity of the will. Let's not forget that a will can now be reduced at either the Sheriff Court or traditionally, as was the case, at the Court of Session if some sort of facility in circumvention is shown. The will is still a competent link in title, but the general consensus is that it is best practice to use a certificate of confirmation as a link in title, and Registers of Scotland, as I say, do still accept the will as a link in title. Financial institutions such as HBOS will distribute up to 175,000 without confirmation. Now, HBOS is the highest of any financial institution that I've came across. I'm also conscious that the Railway Pension Scheme requested confirmation for a claim of around £7 to £10, and I think that at the time the cost of the confirmation certificate was in excess of the value of the claim. Now, as regards applying for confirmation, be mindful of the necessity in relation to the declaration in respect of page 2 of the C1, and that is to say you're narrating the relationship between the deceased individual and the executor. My advice to you is not to use the inventory attached to the C1 PDF. Use an inventory apart on an Excel spreadsheet, which is far easier to edit. Now, if you're struggling with how to design the inventory, then I advise you to examine Curry, and if you've got any other problems in relation to the C1, then also, more often than not, you will find the answer in Curry. I also believe it is good practice to obtain the approval of the executors in relation to the application for confirmation. And I would also advise you that you get a second pair of eyes to examine your confirmation application. I regularly in practice review my colleagues' applications for confirmation, and it is all too common, especially with the trainees, that I note the odd error here and there. The SLCC will inform us that one of the most common complaints against solicitors is failing to keep their clients informed. Therefore, I consider it good practice to send a copy of the grant of confirmation to the executors and to the residuary beneficiaries. When I'm writing out to financial institutions, I'm ensuring that I'm requesting closing statements, and I'm also ensuring that I underline that they should use solicitor's reference, whatever it may be, if making a backs payment. Otherwise, you could be receiving thousands of pounds and your cashier may well be struggling to allocate them to the correct client account. Now, prior to sending any share certificates or confirmation certificates out to the various financial institutions, I'm ensuring that there's a scanned copy, and I'm also considering the position in relation to capital gains tax. I appreciate it is not our role to advise our clients in terms of the tax implications in relation to an estate. This is a matter for an accountant, but you should nevertheless be mindful that the estate will have a capital gains tax allowance of £12,300 at today's rates, whereas if, for instance, you've got a heritable property valued in confirmation at 150,000 and selling for 200,000, and there are half a dozen residuary beneficiaries, it may be more tax advantageous to do a docket transfer to the certificate of confirmation in terms of the schedule to the 1964 Act, and thus utilising the capital gains tax allowance of the residuary beneficiaries, and you're multiplying the capital gains tax allowance by a potential of 6 times as opposed to the 1 CGT allowance of the executory estate. Okay, in terms of your duties to the executors, I consider it imperative to ensure that you're accounting for every single penny that comes in and goes out of the estate. I would ask that you provide your executors and the residuary beneficiaries, for that matter as well, with an account of charge and discharge, and it is best practice to have the accounts signed by all executors stroke residuary beneficiaries. You're giving clear narration in terms of the accounts as to dividends, payments to HMRC, etc. And in terms thereof, HMRC do operate a de minimis principle. That is to say, if the tax and interest owing to HMRC is below £100 or the tax on dividends is below £10, you're not required to give notice and make a return to HMRC. Now, beneficiaries are entitled to a Form R185, and the charities will ask you for a copy of this form if tax has been paid to HMRC. We have already touched upon CGT in the previous slide. I would just ask you to be very mindful that if there is more than one beneficiary to the estate, you have a duty of care to your client, and it may be advantageous to transfer the assets of the estate to the beneficiaries before realisation, thus minimising the CGT charge to the estate. Now, if there is a capital gains tax return required, you should be instructing an accountant. At the end of the day, we are solicitors, not tax specialists. Your accountant should be knowledgeable of the additional allowance available for estates, and this arises in terms of the lesser known HMRC Statement of Practice 204, set at a fixed sum. Now, CGT is chargeable at 20% for movable property and 28% for heritable property. In a case I recently dealt with, the confirmation value of the heritable property was £380,000. It sold subsequently for £425,000, a gain of £45,000. This particular gain is calculable in terms of CGT, not inheritance tax. So 28% at £45,000 is a considerable sum if you can alleviate the burden of the CGT by transferring the asset to the beneficiaries prior to sale or realisation of the asset. This will be appreciated by your clients. Now, if you're in doubt at all in relation to inheritance tax, then you can obtain an IHT 30, which is a clearing certificate from HMRC. The next part of this presentation will be in relation to some problem executaries which I have encountered, and in terms thereof we will be concentrating upon the following particular points in the slides to follow. During the course of the last year, I had a file mandated out from another firm to my firm, and the surviving son of the deceased had stated that no action had been taken in relation to the executory estate. He was wanting to move matters forward. I perused the terms of the will, and I was disappointed to read that the deceased elected to appoint her spouse, Ian McGlumford, whom failing within 1 calendar month of the date of my death, my son Thomas McGlumford. Therefore, the deceased, in accordance with the will, was only accepting Thomas McGlumford as an executor if Ian McGlumford had passed away within 1 calendar month of the deceased. As it was, Ian McGlumford survived for some 3 months after the death of the first deceased. Unfortunately, Ian McGlumford was incapax and not able to take up the role of an executor. Upon Ian McGlumford passing away, I applied for confirmation on the basis that Thomas McGlumford was entitled to the role of the executor in accordance with Section 3 of the Executors Scotland Act of 1900, and that is to say that he was entitled to the appointment by virtue of the fact that he was the residuary legatee in terms of his father's will, and I subsequently appointed him as executor to his mother's estate by virtue of his role as the representative of his late father. Now, had the individual who took the instruction in the first instance read over the terms of the will, then they would have realised the issue in which they were creating in this particular estate. Staying with the issue of executors, if you're struggling to convince an executor to act, then you may wish to use a deed of declinature and assumption. Be mindful of the fact that a sole executor cannot resign office without assuming an executor to the position. If you simply do not have an executor by virtue of the fact the sole executor has passed away or is incapax, then your solution may well lie within the Executors Scotland Act 1900, Section 3, as per the previous slide. Turning to the rather difficult issue of removing an executor from office. The current procedure is a petition to the Court of Session, which can be an expensive road to travel. Where confirmation has been granted, an executor can be removed if they breach the principle of octorem rensum, that is to say they're acting in their own interest. Now, executors at war with one another, I have previously held an initial meeting with potential clients. I hadn't engaged them as clients at that stage. The executors despised one another. They were brother and sister. They used several expletives in terms of the initial meeting. I went on to advise them that I was not prepared to administer the estate of the late mother if they both insisted on maintaining the role of executor. As it was, one of them resigned office and I moved forward on that basis. In terms of removing an executor, well, you simply cannot remove an executor owing to conflict. There must be more than a simple conflict between the executors. An incapax executor cannot act if the deceased executor is unable to be contacted. Well, it used to be a case that they could be removed from office if they were out of the country for a period in excess of 6 months. This is less applicable owing to modern technology in terms of communication with executors. In terms of questioning the validity of a will by raising an action for reduction of the testamentary deed based on facility and circumvention, it is vitally important to prove the testator does not have capacity to give proper instruction. Let's not forget the law presumes in favour of the testator's capacity. Now, a weak-minded individual is still capable of giving valid instruction. As regards facility, it is susceptibility to persuasion that it is vital, whereas circumvention may arise when there is a form of solicitation, improper or perhaps inappropriate suggestion in relation to the testator. Turning to the case of Morrison v Maclean's trustees, the testator's will was held to be valid, despite the testator using obscenities in everyday life, and also claiming to have been fed from an eagle's nest when young. Now, perhaps one of the most important things when taking instruction is laying the groundwork. Now, my own firm was asked to take instruction concerning an elderly lady. There was conflict within the family, and her nephew was a practicing sheriff at the time. Now, prior to taking the instruction, we ensured that we had a medical certificate of capacity. The elderly lady changed her will on 2 subsequent occasions, and on each occasion we ensured that there was a medical certificate of capacity. When the client passed away, inquiries were received as to regards the nature of the meeting. Now, we exhibited the certificates of capacity, and that was the end of the matter. Now, my colleague has previously received instruction from a client to euthanise her pets when she passes away, and this is a matter for my colleague to grapple with, but this in itself does not prove that the testator is not able to give proper instruction. Domicile in relation to a deceased is fundamentally important, not just in terms of the C1 application. In my own practice, I took over a phone call that I heard my paralegal state that I think you will have to instruct a solicitor based in England. I made further inquiries, and it transpired the deceased had moved to England owing to ill health, but it was such that their investments, some of their family and some of their property remained in Scotland, and as such I made an application to Edinburgh Sheriff Court on the basis that the deceased had no domicile except to say the same was held in Scotland. And in terms of that particular estate, my firm proceeded to administer that particular estate, and we duly received the fee in terms thereof. Had I simply let that call go, that would have been an instruction that would have ended up in the hands of an English solicitor. So it's perhaps worthwhile ensuring that junior colleagues are aware of the principle of domicile. Now, you're also advising their clients, if they raise the issue, then they're balancing legal rights against the provision for Family Dependents Act 1975, which is the case in England. Arguably, the greatest skill requirement of an executive practitioner is the ability to realise the limitations of their own ability and when they should seek assistance, and arguably this is especially true of trainees. Now, my own firm has a trustee company, and we are appointed to fulfil the role of an executor in terms of a large number of our clients' wills. We dealt with deceased A who passed away in 2008, and we duly administered her estate. All that was left was a half-share inheritable property owned in common with B, who passed away in 2014. Yet again, my own trustee company was appointed as a co-executor, and the remaining executor was out in the United States. Now, when they purchased the heritable property in the first instance, there was a minute of agreement relative to the purchase price. A had paid the majority of the purchase price. When B died, the executors went to war somewhat. The second co-executor claimed that it was a conflict. She lodged a complaint with the Law Society and the SLCC, and it wasn't the easiest in terms of dealing with this particular individual, because she was residing in the United States, she was avoiding service of court documents, etc. At the end of the process, my firm was exonerated, as was the solicitor in question, by both the Law Society and the SLCC. Now, the mistake that my former colleague made was not realising the limitations of her own ability, and that is a skill set that I would underline that trainees must be acutely aware of. If in doubt, ask your supervising solicitor. I would just like to go over some final points. As regards deeds of variation, ensure that the deeds of variation are signed prior to the 2-year deadline after the date of death. Now, in my own practice, it is a policy to attend in twos if we are attending the heritable property of a deceased individual. On one occasion, myself and my colleague uncovered $54,000 in a suitcase. We did, of course, make a report both to DWP and the SAR report. Now, if you're looking to avoid service complaints, be organised, and you'll find an example of how I organised myself as a trainee within page 84 of the handbook. Now finally, a profile of a profession which was undertaken a few years ago highlighted the fact that the majority of solicitors were seeking to leave or considering leaving the profession within the next 7 years, and that 3 trainee solicitors were also considering leaving the profession in the same time period. My message is that your trainees are going through a steep learning curve. It is for the trainees to take personal responsibility and ensure that they can be the best in which they can be. Be mindful of the fact that your trainees will make mistakes, but hopefully they shall certainly learn from their mistakes and improve during the 2-year traineeship. I would like to thank you for listening to this presentation on behalf of the Scottish Law Agent Society.